Well, good evening, everyone. We will officially convene this public meeting of the Civil Service Commission of Metropolitan St. Louis Sewer District on January 17th, 2025 at the MSD offices. Sitting for the commission are Bishop Michael Jones as chairperson, Marilyn Sims as one of our members of the commission. On behalf of MSD is myself, Tracy Coleman, Director of Human Resources, and Tim Snoke, Secretary Treasurer for MSD, Todd Oshbacher, General Counsel for MSD, and Josh Sindel with the Office of General Counsel for MSD. Carolyn Hill, Reporting Services, our court reporter. We are here today to review proposed changes and discussion of submitted public comments regarding the proposed updates to the civil service rules. The district concluded negotiations with the labor and trade unions in 2024. The new collective bargaining agreements, I will refer to through the rest of the session as CBAs, require an update to the civil service rules. We also took an opportunity to update existing rules for clarification, changes in the law, and to align with our current business practices. The proposed changes to the rules were emailed to all district employees on November 26, 2024. Union business agents were emailed proposed changes on November 26, 2024. Public meeting notices were posted on bulletin boards and social media on December 2nd, 2024. Public comments were due before Monday, December 9th, 2024 at 3 p.m. Central Time. And all comments read during this meeting were received prior to the aforementioned deadlines. Tonight, we do have two public comments which we're going to allow. First, starting with Frank Valroy, if you can come to the mic. Frank, we do ask you that you limit your comments to 5 minutes.
Yes, ma'am. All right. Good evening. Thank you for the opportunity to address the board this evening, and thank you for the service that you guys provide to the community. Once again, my name's Frank Valroy. I'm a representative with IBEW Local 1. At the negotiating table, I speak for roughly 80 of the district's tradesmen and women. I'm here this evening to speak on proposed changes to Civil Service Rule 13.5H. I believe you all have my comments, so I won't bother reading them for you all. So on March 26th of last year, MSD Management and the trades executed a tentative agreement. This agreement addressed hours, wages, and working conditions for those employees of the district. The proposed changes to Rule 13.5H would also affect those factors and should be bargained over. This board has an opportunity to show the district and its employees that the collective bargaining process is the foundation on which this organization sits. Without this foundation of cooperation, the success that the district and its employees have created would cease to exist. The collective bargaining process ensures that both sides have a voice, fostering fairness, transparency, and mutual respect. By bringing this proposal to the board and not the bargaining table, the district risks undermining that respect and trust, as well as the success of the district. Pardon me, I don't do a lot of public speaking. It sends a message to district employees that their rights and input can be disregarded when they're not convenient. And that's a message that no organization can afford to send. I ask that this board consider the long-term implications of their decision this evening. Choosing to reject this proposal, or these proposed changes to Rule 13.5H, is a choice to honor and respect the collective bargaining process, as well as a choice to honor and respect the people who have in the past and continue to build their livelihoods here at the district. It is a choice to preserve the trust, stability, and principles that we have built over the years together at the bargaining table. I ask that this board please allow us to work together through that process which we have agreed to together, so that we may find a solution that respects everyone's role and ensures a stronger future for this organization and its employees. Thank you.
Next public comment is John Koroff. And John, I would just ask you to limit your comments to 5 minutes.
Okay, thank you. Thank you, commissioners, for the opportunity to speak this evening and for your service to the community. My name is John Karhoff. I'm an IBEW representative, and I represented the IBEW member employees of the Metropolitan Sewer District from 2011 until 2023. During that time, I believe, other than occasionally we bump up against each other, we built a strong working relationship over those many years. First with Director of Operations, Jonathan Sprague, and then the Director of Operations, Brett Berthel. I have not worked personally with the current Director of Operations, but I have worked with Tracy, and I've appreciated the strong relationship that the trades have with the district. We've always been able to come together and mediate our differences. But I wanted to come tonight because I regret that I don't have, I have a lot of history with the district myself personally, and I know how this particular rule was managed for those many years. This, to me, was concerning in my discussions with my colleague Frank Valeroy, because it appears to be unilateral action that the district has taken to change the terms and conditions of the employees we represent outside the collective bargaining process. And to me, this is a unilateral action by the district that they've never taken before in my history. And so I was alarmed by it, and I'm just here tonight to echo and support my colleague, who's one of the most talented young guys that I've ever met, and I apologize to him that he's confronting this right out of the gate as a new representative for these employees. And I hope the commission and the district will see fit to sit down at the table with us and resolve this through the collective bargaining process, rather than just mandating implementing this new rule, which will, we believe, have some serious impact on the members and their ability to serve the district on this emergency callback issue. So thank you for your time this evening. Thank you.
So I'll proceed with the changes, Commissioners, and I'll start with Rule 1 definitions. Rule 1.58, suspension on page 10, we're asking for the to remove unpaid from that. The rationale behind that is that a suspension may be paid or unpaid as determined by the appointing authority. Moving on to Rule 4, applications and examinations. Rule 4.2, notice of examinations on page 18. Removed posting of paid advertisement in newspapers and periodicals. Removed time, place of an official announcement of examination and replaced with notice of application deadline. The rationale is just to update the language, as those previous language was outdated methods regarding posting of job openings. Moving on to Rule 4.5H, disqualification of applicants on page 21. Updated the verbiage from tested positive on a substance abuse to failed. Rationale for that is this change aligns with the changes made to MSD's substance abuse policy concerning marijuana usage. Rule 4.8A, method of rating and minimum grades. That's on page 24. Added the minimum passing score of at least 60% to meet eligibility requirements for an examination. The rationale behind this change memorializes MSD's minimum eligibility requirements to be considered a passing score for the examination. Rule 4.8B, consideration for lower job titles on page 25. Replaced an applicant who fails to gain eligibility with fails to receive an offer of employment. The rationale behind this change is if an applicant does well in an interview, but is not offered the job because there's a more qualified candidate, the applicant may still be considered for a lower position, which again is the rationale behind that particular change. Moving on to the bottom of page 1, we're talking about changes to Rule 6 under certification and appointment. Rule 6.1, request to fill a position on page 33. Replace submit a request with create a requisition to fill a position and replaced on form prescribed by Director of Human Resources with applicant tracking system. The rationale behind the change was to update, it was updated based on the new use of technology and outdated practices for the hiring process. Rule 6.2A1, appointment through demotion, involuntary demotion on page 33. Added point 6 to Rule 11. The rationale clarifies a specific subpart of the original rule. Rule 6.2G, appointment through reinstatement, page 36. Updated regular status to regular employee status. The rationale behind that change tracks with the definition of a regular employee in Rule 1.48. Rule 6.2G5, appointment through reinstatement on page 37, added including after the review of former employees' previous performance and any reasons for which past disciplinary action was taken. Rationale permits MSD to review an employee's past performance reviews and records of discipline prior to determining eligibility for employment. Rule 6.2H, appointment from original appointment list on page 37. Added that appointments from original appointments shall be made in order of final qualifying grade received from highest to lowest. The rationale for this change clarifies that the ratings from the original appointment will be ordered in grades from highest to lowest. Rule 7 regarding the probationary period. Rule 7.6C, following the removal during the promotional or transfer period on page 46. Added that temporarily reassigned employees shall have a maximum of 180 days from when the employee begins performing the temporary duties to find a permanent position. The rationale behind this change clarifies that the 180-day period starts running once the temporary assignment begins. Rule 8, employee conduct and relations. Rule 8.1, discrimination and favoritism prohibited on page 48. Added pregnancy to the protected class. Rationale behind this change is that MSD implemented a new reasonable accommodation for pregnant workers, and that policy happened in 2024, so this is just updating and matching the language in the policy. Rule 8.6, attendance and reports of absence on page 53. In the original published version, remove the words regularly from scheduled working hours and scheduled start time, and adding including regularly scheduled work and overtime. There were 2 comments about that change, which I will read for you. IBEW Local 1 and IUOE Local 513 commented. These groups were commonly referred to as the trades. IBEW opposed the change in section 8.6 to add including regularly scheduled work and overtime. It is our contention that this section 8.6, attendance and reports of absence, shall be amended as follows. Regularly scheduled work and scheduled overtime in which the employee has agreed to provide services at a given time, as well as overtime designated an emergency as defined by Civil Service Rule 13.5 Part B. Example of that would be like flood duty. MSD's response, MSD will agree to modify the original published version by simply deleting 2 references to regularly scheduled working hours and scheduled start time, dropping these phrases, including regularly scheduled work and overtime, and including regularly scheduled work and any scheduled overtime. IBEW's proposed amendment, which only permits overtime if the employee agrees to it, the district's position is was not bargained for, violates existing Civil Service Rule 13.5.B, overtime on page 84. Departments may prescribe reasonable periods of overtime work to meet operational needs. Read Article 13 of the Trade CBA, page 18. The scheduling of overtime work may be required to meet specific work demands. New proposed rule, all employees in classified service shall be in attendance at work during their scheduled working hours, subject to other provisions of these rules. Employees shall notify their immediate supervisor or other designated persons of their inability to report to work no later than the scheduled starting time. SEUI Local 1 comment, we disagree with the proposed change as it was not bargained with the unions. Added scheduled overtime. We suggest modifying or clarifying the proposed language as follows. Include regularly scheduled work and scheduled overtime work. MSD's response is, please see the proposed rule that we just read above. The rationale simplifies that the employees are expected to report to work at their scheduled time, regardless of whether it's a normal work or overtime work. Moving on to Rule 11, layoff procedures, separation, and disciplinary action. Rule 11.6.A.2, suspension on page 65. Updated to clarify, unpaid suspensions only cannot exceed 10 days. And added, an appointing authority may suspend an employee with pay pending an investigation of charges against the employee. The rationale behind this change is that a suspension may exceed 10 days if it is paid. For example, in an instance where it may take more than 10 days to investigate a complaint or charges against the employee will be paid during that time. Rule 11.6.B19, reasons for which disciplinary action may be taken. That's covered through pages 66 through 69. The new rule, causing or committing willful, neglectful, or repeated violations of material safety standards and practices outlined in the district's safety procedures and guidelines manual, or allowing any such violations to occur. There are some safety violations serious enough to warrant immediate suspension or dismissal without progressive discipline. Examples of serious safety violations include, but is not limited to, trenching and shoring violations, confined space entry violations, operating a district vehicle with an elevated boom, or failure to properly lock out, tag out energized equipment. There were 2 comments to that change. Matthew Dirk in operations commented, examples of serious safety violations include, but is not limited to, improper use of trenching and shoring, confined space entry, elevated boom, or lock out, tag out equipment. MSD's response to that comment is the current proposed language memorializes the language included in the district's safety procedure and guidelines manual. For consistency reasons, the language should be the same. SEIU Local 1 commented, we disagree with the proposed change. This change was not bargained, and the district is seeking to achieve something that it was not proposed or bargained that should have been. The union would like the commission to reject this in its entirety. However, should the commission attempt to approve, we believe that there should be a step prior to dismissal, as it could be a learning experience. MSD response to that comment is dismissal is not required under the new rule and will depend on the situation. For example, the rule states that suspension may be warranted. Progressive discipline may still apply and is permitted if warranted by the situation. None of the CBAs make specific reference to the conduct identified in subparts 1 through 18. So the not bargained for comment is immaterial to this new rule. The rationale behind this is the district's safety procedures and guidelines manual already identifies serious violations that can warrant immediate suspension or dismissal without progressive discipline. However, this portion of the manual should be incorporated into the civil service rules for consistency. Moving on to Rule 13, the compensation plan. So commissioners, I want you to understand you're going to hear me make a lot of letter changes. Previously, we've had schedules A, B, and C, A, B, B, T, and C. With the new schedules of people working 4 days a week, we've had to add B1s, B2s, A1s, A2s, and so you'll hear me make those changes throughout. So starting with Rule 13.4A, starting rate on initial employment, page 78. Consolidate statement into including existing and new schedules. original appointment to any classified position within the current A1, A2, B1, B2, B3, and BT or C schedules shall normally be made within the first quartile or step of the salary range. Moving on to Rule 13.4.d, starting rate of displaced employees, page 79. Replace pay schedule with B, replace schedule B with B1 and added B2, B3 and, to second paragraph. Replace schedule A with A1 and added A2 to the third paragraph. Rule 13.4.E.1, starting rate on restoration of original position. That covers pages 79 through 80. We replaced Schedule B with B1 and added B2, B3 to the second paragraph. Replaced A with A1 and added A2 to the third paragraph. Rule 13.4.E.2, starting rate of restoration position lower than original position on page 80. Replaced B with B1 and added B2, B3 to second paragraph. Replaced Schedule A with A1 and A2 to the third paragraph. Rule 13.4.F.1, starting rate on recall original position, page 81. Replace Schedule B with B1 and added B2, B3 to the second paragraph. Replace Schedule A with A1 and added A2 to the third paragraph. Rule 13.4F.2, starting rate on recall, positions lower than the original position, which covers pages 81 through 82. Replace Schedule B with B1 and added B2, B3 to the second paragraph. Replace Schedule A with A1 and added A2 to the third paragraph. Rule 13.4G.1, starting rate on promotions, page 82. Replace pay Schedule B with B1 and added B2 and B3. Rule 13.4.G.2, starting rate on promotion, page 82. Replace Schedule A with Schedule A1. Rationale for all the changes in 13.4, new pay schedules created by the 4-day work week. Moving on to Rule 13.5A, regular working hours from page 84. Revised maximum work hours per day from 8 to 10 or 9.5, depending on the pay schedule and the normal work day. The normal work week shall not exceed 5 days, and there was one comment to that. Jeremy Boyer in engineering commented the typo is as follows. It says 10 when it should be 9.5. MSD's response: we acknowledge the typo. However, the revision to the rule should reflect 10 hours, not 9.5. Rationale: it takes into account the new 4-day work week as a result of union negotiations and the new CBAs. Rule 13.5C, eligibility for overtime or compensatory time for schedules A, B, BT on page 85. Replace Schedule A with A1 and added A2. Remove BT and added B3. Added pay schedules for A1, A2, and B3. Employees working 40-hour, 5-day per week may elect compensatory time, and there was one comment to that. SEIU Local 1 commented the union disagrees with this change. SEIU has had team leaders in operation who work 4 10-hour days on Schedule B3. Additionally, there needs to be provision added for SEIU that should the district reinstate the 5-day scheduled that employees on B2 and B3 shall be eligible for compensatory time that they bargained for. MSD's response is part 1, MSD acknowledges SEIU's first comment about the union employees working a schedule for 10 hours per week, 10-hour days per week, MSD agrees to modify the proposed revision and remove the phrase 5-day. The new proposed rule, Pay schedule A1, A2, and B3 employees working 40-hour work week may elect to receive compensatory time off in lieu of overtime paid in accordance with the district's overtime compensatory time policy. MSD's response to Part 2. SEIU's second comment is not an issue to be addressed by the civil service rules. MSD will address this issue separately with SEIU. The rationale that these changes align with the new CBAs. Rule 13.5F, compensation for overtime worked, page 86. Replace Schedule A with A1, added A2, and replace pay Schedule B with B1 and added B2, B3. Removed or unless otherwise provided in a revised schedule established pursuant to Rule 13.5, 8 hours per day. Added reference to the extent permitted by Rules 13.5C and D, and there was one comment. SEIU Local 1 comment, the union disagrees with this change. SEIU has a team leaders and operations who work 4 10-hour days on Schedule B3. Additionally, there needs to be a provision added for SEIU that the district reinstate the 5-day work schedule, that employees on B2 and B3 shall be eligible for compensatory time as we bargained for. MSD's response is, please see the response to 13.5C that we already discussed above. Rule 13.5H, callback pay, which covers pages 86 through 87. Replace pay schedules with A and B with A1 and B1 and added schedules A2, B2, B3. For pay schedules A1, A2, B1, B2, B3, and BT. And Schedule C, employees designated eligible for overtime pay added who work 40 hours per week and are called back to the district facilities for work locations and for each instance thereafter. Added classified employees in pay schedules A1, A2, B1, B2, B3, and BT, and classified employees in Schedule C, designated eligible overtime pay who work a regular schedule less than 40 hours per week and are called back to the district facilities or work locations to perform work or render services outside of their regular working hours shall be paid at the appropriate overtime rate for work performed in excess of 40 hours per week. And for each instance thereafter, be paid a minimum sum equal to compensation for 4 hours at the appropriate overtime rate. Added to the extent agreed upon with bargaining unit employees, those employees who provide callback services. Replaced minimum of 1.5 hours overtime to minimum of 1.5 to 1.5 hours of regular pay as actually worked added, and overtime pay for any callback services provided in excess of 40 hours per week. Remove the foregoing provision foregoing provision shall not apply to bargaining units employees except to the extent agreed, There were 4 comments to this. IBEW Local 1 and IUOE Local 513 commented. And again, commissioners, those we consider the trades when you hear us refer to them. MSD's response, there is no provision either in the CBA or the current civil service rules stating that callback pay is always paid at an overtime rate. The CBAs and the civil service rules refer to the appropriate rate. During bargaining with the unions, MSD stated clearly and unequivocally that there is a 4-day work week was implemented. Daily overtime would no longer apply, and overtime would only start after working 40+ hours per week. That is the law under FSLA. The unions agreed with this proposal and never raised any issue concerning callback pay. MSD acknowledges that callback pay has historically been paid at time and a half, but the reason for that is because prior to implementation of the 4-day work week, Union employees traditionally worked a 40-hour work week and were eligible for overtime worked in excess of 8 hours per day. So when an employee was called back to work to perform callback duty after working their standard 8-hour shift, it generally automatically resulted in an employee exceeding 8 hours of work for that day, which meant the entire 4-hour callback period was OT eligible and paid a time and a half. It's not the district's responsibility to raise an issue during negotiations, nor is it a breach of duty of bargaining in good faith. Jeremy Boyer in engineering commented, the number consistency error is as follows, says less than without the number 40, should say less than 40, like the others around it to specify the amount. MSD acknowledges that error and agrees that, and it has been corrected. SEIU Local 1's comment is, SEIU objects to this language change. The district did not bargain this, thus gaining a concession without bargaining the concession. SEIU has not agreed to 1 and 1.5 hours of callback pay for remote work rendering services at any time and has always maintained the 4 hours of callback pay. Callback pay is at any time the employee provides a service to the district outside of normal working hours. Additionally, the district did not bargain for the change of callback pay. 13.5 has always been and should remain a minimum sum equal to 4 hours at 1.5 times the employee's hourly rate. MSD's response is, please refer to the comment previously stated before about callback pay. MSD response on part 2. MSD acknowledges that SEIU has not agreed to the 1.5 hours of callback pay for remote work. That part of the rule explicitly states that it only applies to the extent agreed upon with the other bargaining units. MSD's response to that is, again, to just see the comments that we previously said before. Rule 13.5.I, standby pay on page 87. Updated from 8 a.m. to 6:30 a.m. Updated reference to compensation as provided in Rule 13.5E and F to Rule 13.5H, callback pay. The rationale is to match operations' new schedule and to clarify that standby pay is paid at the same as callback pay. Rule 13.6A, holidays on page 88. Added Juneteenth, which is June 19th, as the additional holiday. Rule 13.6B, floating holidays on page 88. Updated eligible employees who have successfully completed 60 days of employment from their date of hire instead of completion of original probation period pursuant to the district's floating holiday policy. Added an employee terminated prior to completion of their original probation is not entitled to compensation for floating holidays. The rationale is language tracks the new floating holiday policy implemented by MSD. Rule 13.6C, holiday observance on page 89. Added for employees with regular work schedule of Monday through Thursday. Holidays which fall on a Friday shall be observed on the preceding Thursday, except for Thanksgiving Friday holiday, which shall be observed the preceding Wednesday. Rationale takes into account the 4-day work week. Rule 13.6D, compensation for observance of a holiday on page 89. Remove the reference to daily overtime, and there was one comment for that. Paul Klages, operations commented, I have an employee that has exhausted all of his PTO and is using the status of unpaid FMLA leave. He is called in using unpaid leave FMLA the last 2 holidays. Does unpaid leave FMLA qualify as paid leave regarding the above rule? I believe I had the same issue a few years ago and the employee did not get paid for the holiday, and I am looking for clarification on this rule. MSD's response is this was a specific personnel issue that was addressed offline and is not part of this proceeding. Rule 13.6E, compensation for work performed on a holiday on page 89. Replace with Schedule A with the Schedule A1, and added A2 and A3, and replace pay Schedule B with B1 and B2, and remove the reference to daily overtime. Rule 14, leave of absences. Rule 14.1.B.1, computation of vacation leave, regular employees, pages 91 through 92. Added, unless otherwise specified in an applicable collective bargaining agreement. Note that revision request is now being withdrawn. The new update is updated maximum accumulation to the end of the payroll year to the end of the calendar year. Updated eligible employees who have successfully completed 60 days of employment from their date of hire instead of satisfactory completion of the original probation period. Removed, an employee may not use vacation time during the original probationary period. And the rationale is that it tracks MSD's current vacation leave policy. Rule 14.1C, vacation leave during military service on page 93. Added, in the lapse of 1 day of continued service following the employee's return from military leave under Rule 14.5. Remove the following requirements. The employee's successful completion of the employee's original probationary period as specified in Rule 7.1 and 7.2, if not completed at the time of the commencement of military leave, and the elapse of 1 day of continued service following the employee's return from military leave under Rule 14.5. The rationale, again, is that it tracks with MSD's current vacation leave policy. Rule 14.1D.2, emergency vacation leave on page 94. Added 38 hours for those who are on 9.5 hours. This revision contains a typo, as it should be 28.5 instead of 38, the equivalent of 3 full days off. SEIU did have a comment about this change, and SEIU believes that the rule should state days. MSD's response to the comment is the comment does not relate to the proposed revision, as the existing rule already refers to hours, not days. The changes track the language of MSD's current vacation leave policy. Rule 14.1D.4, vacation leave to supplement workers' compensation, benefit, or other paid leave, page 95. Added depending on the employee's regular working hours and removed in revised schedule. Rule 14.1G, vacation sellback program, page 95, new rule. Vacation sellback program, classified employees shall be eligible for vacation sellback from the district in the manner and the amounts described more particularly in the district's vacation leave and sellback policy. Rationale tracks language in the vacation leave policy. Rule 14.2, education leave on page 96, added in accordance with the district's tuition reimbursement policy. The rationale is just a reference back to the policy. Rule 14.3B.3, sick leave, exclusions from sick leave paid on page 100, updated from 90 days to 60 days. The rationale is that it follows the current sick leave policy. Rule 14.7, bereavement leave on page 101, replace the maximum of 32 hours with a maximum of 38 hours based on work schedule, added or within 14 days of the funeral service. The rationale is that it accounts for the new 4-day work week. Rule 14.8, compassion leave, page 101, that is a new rule. When a death occurs to an employee's brother-in-law, sister-in-law, aunt, uncle, niece, or nephew, 1 day paid compassion leave will be allowed per calendar year. Usage shall be restricted to attendance funeral services, and supporting documents must be provided to receive pay. Rule 14.9, absence for voting on page 101, was renumbered from 14.8 to 14.9. Rule 14.10, absence for jury duty / witness pay on page 102, renumbered from 14.9 to 14.10, and added employees required to immediately notify his or her supervisor upon receiving such subpoenas. Rationale follows the language in the CBAs. Rule 14.11, leave without page on page 102, renumbered from 14.1 to 14.11. Rule 14.12, special leave on page 103, renumbered from 14.11 to 14.12, and updated reference to Rule 14.10 and 14.11. Rule 14.3, FMLA leave on pages 103 and 104 were renumbered from 14.12 to 14.13. Added unpaid leave under FMLA. Updated coverage period per year to in a single 12-month period. Added to reason number 2, in order to care for that child. Rationale provides clarification on FMLA rights and tracks with the language in the current policy. Rule 14.4, administrative leave on page 104, renumbered from 14.13 to 14.14. Rule 14.15, domestic violence leave on page 105, which is a new rule. Employees who are victims of domestic violence or have had a family or household member who is a victim of domestic violence shall be entitled to up to 12 weeks of unpaid leave during any 12-month period as set forth to the extent allowed by the district's Victim for Economic Security and Safety Act, the vessel leave policy. The rationale is it's a new policy since the customer service rules were last updated. Rule 14.16, bonding leave on page 105, was renumbered from 14.14 to 14.16 and added up to 4 weeks of paid bonding leave. The rationale is that it clarifies the maximum allowable per bonding leave policy. Yes. Yeah. Can we just take a quick break for one moment? Commissioners, I've been asked to read the entire submitted comment, not the summarized comment from one of our unions. So I'll read that now. It's the attachment that you guys have in your book, but I'll read it. MSD reached an agreement with the trades on the 4 days work week, which did not include any changes in callback pay. MSD is using the Civil Service Commission to seek additional concession related to the 4 days work week, which was not negotiated, conflicts with the parties' collective bargaining agreement, interferes with the constitutional rights to engage in collective bargaining agreement, and is the misuse of the civil service process. On March 26, 2024, MSD management and the trades executed a tentative agreement, CBA, which subsequently ratified by the trades members. The CBA provided for a 4-day work week in place of the then current 5-day work week, along with the number of specified negotiated changes related to the 4-day work week, specifically 1, working hours from 6:30 a.m. to 4:30 p.m. 2, the new work week will be 38 hours, 4-day, 9.5 hours a day. 3, employees' overall salary will remain the same. Employees' hourly rate will be increased to reflect the 38-hour work week, the same salary level. Work schedules will include a 30-minute unpaid lunch. Overtime will start at 40 hours worked. 4-day work week must be adopted by all MSD bargaining units or will not be implemented. Comp time will no longer be an option. Any employee that has an existing comp balance will be allowed to use their accumulated. The trades and MSD management did not negotiate any changes in callback pay. MSD is using the Civil Service Commission to gain concession on callback pay, which management did not negotiate at bargaining. It is a misuse of civil service management to seek an adoption of a concessionary terms and the conditions which conflict with the CBA reached at the bargaining table, as well as the constitutional rights of Missouri's public sector employees to engage in collective bargaining. The appropriate rate for being called back to the district's facilities after an employee has completed their shift for the day has already left district facilities 1.5 times the employee's regular rate of pay. The parties never negotiated to change callback pay. The new CBA and its 4-day work week do not provide for changes in the Civil Service Rules 13.5-hour callback pay. There is nothing in the CBA related to the 4-day work week which provides changes for current Civil Service Rules 13.5H on callback pay. With respect to the trades members, the first sentence of Rule 13.5H simply states that callback rules to classified employees and pay schedules BT. The trades members are all in Schedule BT. Nothing more is required to be eligible for callback pay if an employee is Schedule BT. Civil Service Rules 13.5H provides callback pay for Schedule BT employees is 4 hours at the appropriate rate. The appropriate rate has been interpreted for years as 1.5 time the straight time rate. For Schedule BT employees, there is nothing in Civil Service Rule 13.5H conditioning either their callback eligibility on overtime pay eligible or setting callback pay appropriate rate at the overtime rate. The words in the first sentence of 13.5H referring to Schedule C, employees who are eligible for overtime pay do not apply to the Schedule BT employees. The second sentence in current Civil Service 13.5H refers solely to the non-bargaining union employees who are able to perform services remotely. The second sentence provides that non-bargaining unit employees are to receive a minimum of 1.5 hours of overtime pay for performing remote services. The third sentence of Civil Service Rule 13.5H provides that 1.5 overtime hour remote service minimum callback pay rule does not apply to the bargaining union employees except to the extent agreed. There is such an agreed upon past practice for remote service in the IBEW group. MSD is asking the civil service to unilaterally end this agreed upon past practice, which is preserved in the current Civil Service Rule. MSD seeks to justify the requested change in the Civil Service Rule 13.5H based solely upon the CBA agreement that the 4-day work week include the terms overtime will start at 40 hours worked. MSD argues that the term overtime also means callback pay. However, a review of the Civil Service Rules show that overtime and callback pay are two separate terms and conditions. The new CBA is silent on changing callback pay. MSD is asking the Civil Service Commission to order concession on callback pay, which MSD never sought in bargaining. The district recognizes that callback pay and overtime pay are different with its own timekeeping guidelines. Page 4 of the district's timekeeping guidelines starts with the heading overtime and goes into how overtime situations should be paid. Page 5 of the district's timekeeping guidelines starts with the premium pay and then goes on to describe when the employee should receive premium pay. The very first topic is callback pay, so it is so because the district has always understood their employees' desire to have a good work-life balance and to compensate them accordingly for going over and above when the district encroaches on valuable personal time with family. For Schedule BT employees, the appropriate rate referenced in the Civil Service Rule 13.5H has always been and should be remain to be a minimum sum equal to 4 hours and 1.5 times the employee's regular hourly rate with the agreed upon 1.5 hour minimum for remote services. I'm sure. I'm going to go back and read the same response that we read previously before for, that was 13 point. Okay, thank you. Okay, so the comment that the district had previously before, after reading the full comment from the unions, is MSD's response is there is no provision either in the CBA or the current civil service rules stating that callback pay is always paid at an overtime rate. The CBAs and the civil service rules refer to the appropriate rate. During bargaining with the unions, MSD stated clearly and unequivocally that the 4-day work week was implemented. Daily overtime would no longer apply, and overtime would start after 40 hours a week. That is the law under FSLA. The unions agreed with this proposal and never raised any issues on callback pay. MSD acknowledges that callback pay has historically been paid at time and a half, but the reason for that is because prior to implementation of the 4-day work week, union employees worked a traditional 40-hour work week and were eligible for overtime for work performed in excess of 8 hours a day. So when the employees were called back to work to perform callback duty after working their standard 8-hour shift, it generally automatically resulted in an employee exceeding 8 hours for that workday, which meant the entire 4-hour callback period was OT eligible and paid at time and a half. It was not the district's responsibility to raise this issue during negotiations, nor is it a breach of the duty to bargain in good faith. Okay. So in conclusion, Commission, the commissioners on behalf of MSD St. Louis Sewer District, we sincerely thank you for your time. This concludes our review of the recommended changes and public comments. The commission will now review the proposed changes to the rules and will make the recommendation on the changes to be adopted by MSD Board of Trustees by ordinance. This meeting is now officially adjourned.